Household and personal items in an Illinois divorce. This discussion explains how household and personal items are treated in an Illinois divorce. It draws from Illinois statutes and court decisions to give you a clear view of your rights when it comes to furniture, electronics, and even wedding rings. Typically, spouses divide most possessions by agreement before they ever step into a courtroom. According to the law office of Russell D. Knight, clients usually split their belongings without much dispute, and whatever is left is later negotiated and memorialized in the marital settlement agreement. The partner who moves out often takes what they need, and minor items rarely justify litigation. As a result, court-ordered divisions of couches and appliances are uncommon. Illinois law distinguishes between non-marital property and marital property. Anything acquired before the wedding date is presumed to be non-marital. If an item was purchased before marriage, it remains with the spouse who obtained it, and the court must assign that property to that person. Classifying items can be tricky when couples live together before marrying because things acquired during cohabitation are still treated as non-marital if bought before the wedding. When spouses disagree about the acquisition date, each must present evidence, and the judge decides based on which testimony is more credible. In Illinois, marital property includes all items and debts acquired after the marriage. Marital property must be divided, without regard to marital misconduct, in just proportions, meaning the split should be equitable, not necessarily equal. Courts dislike being asked to inventory every sofa and washing machine. Instead, they consider the overall value of property assigned to each spouse and the needs of the parties. For example, a spouse who needs a wheelchair may keep it, but if that wheelchair is made of solid gold, the other partner might receive valuable flatware to balance the division. If the item carries a loan, the spouse willing to assume that debt is likely to retain the item. Marital property may include furniture, appliances, and other household goods. They are seldom split 50-50 by number or value. Valuing items can become important when an object has significant monetary worth. Illinois law requires competent evidence to assign value. Testimony from a pawn shop owner is hearsay and inadmissible. Parties who fail to present evidence cannot complain about the court's decision. Often spouses stipulate to the values of particular items, and courts honor that agreement unless it is unconscionable. Household or personal items bought after marriage can still be non-marital if they were purchased with non-marital funds or exchanged for property owned before the wedding. Gifts, inheritances, and property obtained by legacy or descent also remain non-marital. A gift from parent to child is presumed to belong solely to the child. Whether a gift is to one spouse or to the marriage depends on the facts. An item given on one spouse's birthday is likely theirs alone, while something with a card addressed to both may be marital. When one spouse transfers an item to the other, there is a presumption of a gift, but the giver must provide clear evidence to overcome the presumption that property acquired during marriage is marital. Engagement rings are considered gifts conditioned on marriage. If the wedding occurs, the recipient keeps the ring. If you are battling over household items, the law emphasizes fairness rather than strict equality. Dividing property by agreement is efficient, but when disputes arise, courts will follow statutory classifications and equitable principles to resolve them. Because the rules can be complex and evidence-driven, consulting a family law attorney can help ensure your interests are protected. An attorney can also advise on presenting proof of acquisition dates and values and on negotiating settlements that avoid costly litigation. The law office of Russell D. Knight, located at 1165 North Clark Street, No. 700, Chicago, Illinois, 60610, offers guidance on dividing household items and other divorce issues. For more information or to schedule a consultation with a lawyer, call 773-334-6311.